I think, shall we make a start? There are other people who are joining, but we've got enough to make a good start, I think. If anybody can't hear or they've got any other problems, please post a message in the chat. As you are aware, this webinar is part of Doughty Street Chamber's series of webinars reflecting on 10 years of the Equality Act. And this seminar is specific to the employment team, looking at some of the key cases from an employment perspective from the first 10 years of the Act. Thanks very much for joining us on this hot afternoon. I'm sure you couldn't think of anything better to do than be sitting listening to this webinar. Most of the Act, certainly the provisions that we're concerned with today, came into force on the 6th of July 2010. And the Act was in many ways a remarkable achievement in bringing together so many different acts and regular sets of regulations that previously existed. For those of us that are somewhat long in the tooth in our practice, we will remember all too well having to struggle with the different sets of legislation and statutory instruments and the differing definitions that applied. The Act is not a perfect one by any means, but it nonetheless is a remarkable achievement to have managed to synthesize all those concepts under the one roof of the Equality Act, and to do so with relative clarity. I think it's also significant that the Act has been relatively little amended in the years that follow, which perhaps also speaks to something positive about it. There were to be three speakers today. Unfortunately, our colleague Nick Toms has had to drop out a very short notice. Literally in the 15 minutes before we started, he received a message from his son's school that his son has been injured whilst playing sport. I mean, fortunately, it doesn't sound anything too serious, but he's had to rush off to take his son to A&E. So he's very apologetic, but of course we all quite understand the circumstances. And the circumstances were too short notice to find a substitute. You will still have the benefit of his slides, and I'll just sketch out now what we're planning to cover. Obviously, we can't cover everything. You may have seen when you booked, the original title of this webinar referred to 10 cases. When we were discussing content, we decided that 10 was a bit optimistic in the timescale because we want to cover things in appropriate depth. So it's actually a little bit less than 10. And we can't cover all the areas of the employment of the Equality Act that relate to employment, but we wanted to focus on some what we thought were particularly important aspects. So first of all, Claire Overman, who specialises in media law and information law as well as employment law, is going to talk about the scope of the religion or belief protected characteristic, which, as you will all know, has brought up a number of interesting and controversial decisions over the years. And then Nick Toms was going to talk about protection for disabled employees, specifically the key cases relating to the duty to make reasonable adjustments and Section 15 Equality Act claims. I will touch on that very briefly, just so that you can see the issues and reflect on the slides. But as I say, since I've literally had less than 15 minutes to reflect on that, I haven't prepared anything in detail, and I'm really will just be speaking from my general knowledge of those cases. So I hope you'll forgive me if that's a little bit, well, not as polished as one would like, shall we say. And then I'll be talking, and I hope you can spot the difference, and it will sound a little bit more polished, about the development of the concept of indirect discrimination, the key Supreme Court case, and also whether discrimination because of a person's immigration status is covered by the Equality Act, given in particular that that is an ongoing practical issue. We had intended not to be longer than 20 minutes each. I may now be slightly longer covering Nick's topic, but as I say, that I'll only do briefly. We'll take questions at the end, but if you've got questions, if it's easier to pose them as you think of them, then can I suggest that you put them in the chat, please? And then after the talks, we will reflect on the questions and try and answer as many of them as possible. So on that basis, it's over to you, Claire.
Thank you, Heather. And thank you, everyone. I reiterate Heather's thanks to you all for being here on what is a very lovely and sunny afternoon. So thank you for attending. We hope that you'll find this presentation of some use. As Heather mentioned, I'm going to start by talking about the religion or belief criterion under Section 10 of the Equality Act 2010. And I felt like I ought to approach this topic in a true millennial way, being among the junior end of the practitioners in the employment team. And what struck me recently was the Twitter viral meme that went round quite recently, which was the how it started versus how it's going, where Twitter users were invited to post two photos, one reflecting how things were starting out for them and another to reflect how things were going at the moment. So I decided to adopt that very millennial approach to the religion or belief criterion under Section 10. And I want to start by thinking about how it all started and then conclude by looking at how it's going now, with particular reference to the Forstater decision of just last month. The wording of Section 10 is there for you all. You are, of course, very well aware of that wording. And I've highlighted in particular the reference to the religious or philosophical belief, because that's what I really want to focus on, how that concept has been stretched throughout the 10 years since we found it in Section 10 of the Equality Act. Of course, it was in previous legislation, but we're looking at where it's got to today. So the case I want to start with, if Ray, you could move on to the next slide, please, is one with which everybody is well familiar, and that's Granger PLC and Nicholson, decision of the Employment Appeal Tribunal back in 2010. And I mentioned a moment ago that we'd seen the wording of Section 10 of the Equality Act, of course, in predecessor legislation. Now, Granger, you will recall, was actually at the time governed by the Employment Equality Religion or Belief Regulations 2003. But as you can see from the excerpts that I've set out in that slide, the relevant wording was the same. And of course, we know that the Granger criteria have lasted to today, so they have transposed over into the wording of Section 10. A quick reminder of the facts of Granger, and in particular what the belief was there in that case that the tribunal had to consider. And if you go back and look at the decision and the content of the claimant's witness statement that he submitted for this preliminary hearing, he sets it out quite clearly. He said in his witness statement, "I have a strongly held philosophical belief about climate change and the environment. I believe we must urgently cut carbon emissions to avoid catastrophic climate change." And perhaps anticipating some of the arguments that he might come up against, he says, "It's not merely an opinion, but a philosophical belief which affects how I live my life, including my choice of home, how I travel, what I buy, what I eat and drink, what I do with my waste, and my hopes and fears." And he gives examples. He no longer travelled by aeroplane. He had eco-renovated his home. He tried to buy local produce. He'd reduced his meat consumption. He'd composted his waste. And he encouraged others to do likewise. And he concluded the relevant paragraph by saying, "I fear very much for the future of the human race, given the failure to reduce carbon emissions on a global scale." And so the question really, and where this all started, these Granger criteria, were from the issue that had to be determined. Did this constitute a philosophical belief? We're not dealing with the religious belief here, which is often a much easier task. But did this fear of catastrophic climate change constitute a philosophical belief within the meaning of that wording? And if I could move on to the next slide, the tribunal gave us those criteria, very helpful and very specific criteria with which one assesses whether a philosophical belief, given that it can extend far beyond the confines of what one might consider traditional religious beliefs, those criteria help the tribunal to answer that question. And they're set out there. So it's a belief that must be genuinely held. A belief, and as we've just seen from the witness statement, not merely an opinion or viewpoint based on the present state of information. It must refer to a weighty or substantial aspect of human life and behaviour. It must attain a certain level of cogency, seriousness, cohesion and importance. And very crucially, for where I want to go with this discussion, Granger Criterion 5 says that it must be worthy of respect in a democratic society, not incompatible with human dignity, and not conflict with the fundamental rights of others. So those are the key criteria with which everyone is very familiar, that we use to measure or to assess whether or not a philosophical belief falls within the protection of Section 10 of the Equality Act. But it's easy to forget that there are other pieces of guidance given by the tribunal in Granger that again really serves to emphasise the flexibility and perhaps quite broad scope of what constitutes a relevant philosophical belief. So moving on to the next slide, the tribunal also says, for example, and these are a list of negatives, so it's not required to be shared by anybody else. It doesn't have to be life governing. It can be a one-off or sort of a one-issue belief, if you like. Although I think in Granger's case, he really did feel it to be life governing. It's not a disqualified belief if it's based on a political philosophy, nor is it a disqualified belief if it's based on science. And so we've got here, in principle, as we start out in 2010, criteria with which claimants can certainly bring in a very wide range of philosophical beliefs. And so the question really for us is, well, where did we get to with those criteria? How far have we gone in our scope of beliefs that can attract or can fall within the protection of Section 10? And with that, I stopped looking at where we were and I now look at where we are now. And the case I mentioned at the outset is the Forstater case, Forstater and CGD Europe, a decision of the Employment Appeal Tribunal just last month. Just a quick reminder of the facts, although I'm sure everybody is well familiar with them. The claimant, Ms. Forstater, held and holds gender critical beliefs. So her belief or her system of beliefs includes the belief that sex is an immutable concept and it's not something that's to be conflated with gender identity. And this became relevant when she began to engage in debates on social media about gender identity issues. And as she was doing that, she made remarks on social media which some transgender people found offensive and they found to be transphobic. She was then the subject of complaints from her colleagues at work who said that they found her comments on social media offensive, and she was a visiting fellow, and following an investigation, that fellowship was not renewed. And therefore she complained that she had been discriminated against because of her philosophical belief within the wording of Section 10 of the Equality Act. And the starting point was uncontroversial. It is that the Granger criteria, then as now, are the touchstone with which to determine whether a belief falls within Section 10 of the Act. And as I mentioned previously, the key criterion here was Granger 5. Was the belief, or is the belief, worthy of respect in a democratic society, not incompatible with human dignity, and not in conflict with the fundamental rights of others? It's of course very easy when one considers philosophical beliefs like belief in catastrophic climate change, because they don't directly impinge upon the rights of others. But the tricky question that the tribunal had to confront here was where a belief very much does so. And the tribunal was, the employment tribunal at first instance found that her belief didn't fulfill that Granger Criterion 5, and the claimant appealed to the Employment Appeal Tribunal. Now, the Employment Appeal Tribunal was at pains right from the outset of the judgment, given, understandably, the debate that it's engendered about the merits of her beliefs. The tribunal was at pains really to limit the scope of what it was deciding. And it was at pains to stress the very narrow scope of the issue, and that is the first bullet there. That is all that the tribunal was purporting to decide in the decision in June. And it starts out by making very clear that those Granger criteria don't represent a high threshold for beliefs to get over. So Granger 5, as a starting point, isn't a high threshold. It's not a high bar for beliefs to get over. What the tribunal did, the Employment Appeal Tribunal did, was look at where those criteria from Granger had originally derived, where the Employment Appeal Tribunal in Granger derived those criteria. And it looked at the domestic and European case law that the tribunal in that case had regard to. So moving to the next slide, it looked in particular at Article 17 of the European Convention on Human Rights. Now that's a really important article in this case, because it's an article that prevents individuals from using their convention rights with the purpose of destroying the rights of others. The full text reads, "Nothing in this convention may be interpreted as implying for any state, group or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms set forth herein, or at their limitation to a greater extent than is provided for in the convention." So again, that emphasizes the level at which the bar is set. It's not enough that your belief impacts on the rights of others. It really has to be aimed at destroying the rights of others in order to fall outside the protection of Section 10 of the Equality Act. And the tribunal gives some helpful examples of European case law, and it's always quite helpful to see the concrete examples of what the courts have decided fall inside or outside the relevant tests. So in Ibragimov, the publications at issue were from Muslim groups, and they were banned by the state on the grounds that they were extremist and they sought to incite religious discord. In Liliendahl, the statements at issue were derogatory remarks about homosexuals, including specifically their categorization as sexual deviants. And the European Court in those cases held that those were very offensive and unacceptable views to hold, but they did not come within the purview of Article 17. They weren't aimed at destroying the rights of others. And the court made very clear that you're entitled under Article 10 of the European Convention to hold views that others may find offensive and alarming and concerning. But that is the hallmark of a democratic society, that plurality of opinion. And it's only if you actively are aiming at the destruction of the rights of others do you risk falling outside of the convention scheme, and for our purposes, outside the protection of Section 10. And again, other examples that the court itself has given is to say, well, actually, you're looking at quite a narrow group of views that do fall outside this protection. So the examples they give are Nazism, totalitarianism, and espousing violence and hatred in the gravest of forms. Now, looking at that list, it does seem that the bar really is very low for examples as extreme as that to be the ones that fall outside Article 17 and nothing less. The court also made quite clear, the tribunal in Forstater made quite clear that how an individual manifests their belief is relevant to the analysis. Of course, in this case, her belief, Ms. Forstater's belief, was manifested through her social media comments. But it's really only part of the analysis, because what the tribunal is looking at is the opinion of itself. Doesn't matter how you're manifesting it necessarily, and whether you're manifesting it in a way that causes a particular offence or upset to others, but is it the belief itself that causes that is aimed at the destruction of the rights of others, such that it might fall outside Section 10. Moving on then to the next slide. The tribunal, in saying in this case that Ms. Forstater's belief did fall within the protection of Section 10, looked at some relevant factors, or irrelevant and relevant factors. It was quite critical of how the Employment Tribunal had approached the analysis. It was concerned that the tribunal, the Employment Tribunal below, had really been assessing the merits of Ms. Forstater's view. But the Employment Appeal Tribunal was quite clear that that is not relevant. It doesn't matter what the tribunal itself thinks and whether it considers that some tenets of the belief are unfounded. Nor does it matter, said the tribunal, that the claimant was dogmatic in her belief. It said that, that might be said of a lot of people, particularly certain religious beliefs. People are very dogmatic in their beliefs, and that shouldn't be a reason for excluding those beliefs from the protection of Section 10. Nor did it matter, said the tribunal, that the scientific foundations of the belief were, in its view, weak. Again, it said, well, that may be applicable to many religious beliefs, which of course do fall within the protection of Section 10. But what was relevant, and I stress that it was relevant in this case, because every case, of course, to some extent will turn on its own facts. But what was relevant here were a few factors. Firstly, yes, the tribunal accepted that with the Gender Recognition Act, there was now the opportunity for transgender individuals to obtain a gender recognition certificate. But what that did not do was, said the tribunal, erase memories of a person's gender before the acquired gender, or impose the recognition of the acquired gender in private or non-legal contexts. So the legal position, the legal framework for this debate wasn't determinative against the claimant. It was also relevant that the claimant wasn't the only person to hold the belief that she did, and the tribunal noted, of course, the very lively debates that have been had on this subject. It was quite clear that this was a matter that aroused a lot of strong feelings in people. And certainly the claimant wasn't the only one to have strong feelings on the issue. Also relevant, said the tribunal, was that the claimant's belief was in fact consistent with the current legal position, which it did determine that gender was, a person was one of two genders, and that of course may change, but the tribunal was particularly troubled by any suggestion that a belief that was in keeping with the current legal position would be a belief that fell outside the protection of Section 10. Moving on to the next slide, and just my final few points on this then. So having looked at all of those relevant and irrelevant factors, as I've said, the Employment Appeal Tribunal did hold in the end that the claimant's belief was one that was in principle protected by Section 10. It said that there was no sense at this stage, and of course this was a particularly relevant issue given the type of belief that was being considered, but it wasn't a question of balancing competing rights, those of Miss Forstater and those of the individuals who were targeted by her, or who felt offended or were the subject of her comments. That wasn't the issue. The issue at this stage was whether or not her belief met that very, very low bar of Granger 5. And again, the tribunal was at pains to stress that it would be very few and very, very extreme beliefs, those that were aimed at the destruction of the rights of others, that wouldn't meet that low threshold. And that gives rise to some interesting points, which I throw open for discussion today. Given how recent this decision was, of course, there is no doubt going to be more to say on this subject, but it certainly, for me, became very topical in light of some of the social media activity we have seen against sports people, particularly sports people of colour, an obvious example being after the European finals. Employees may write things on their social media accounts, things that are particularly vitriolic, offensive, racist, prejudiced, bigoted, and they may well fall foul of employers' policies on social media use, for example. But is there scope for individuals? And of course, it wouldn't be a case of asserting one's belief, it would be a case of being able to satisfy all the Granger criterion. But individuals may say, well, I'm sorry that these opinions do offend sections of the population, but they are opinions that I hold and that fulfill the criteria. So there are bound to be some interesting cases on the back of this where we really do test what seems to be quite flexible concepts and quite broad concepts within the Granger criterion. Forstater is an example of where we've pushed the boundaries quite far. And the question, I think, for cases to follow this will be, where else is it going to be pushed, and what are those other pressure points, particularly whereas here they are beliefs that really engage quite obviously rights of others who may be the target of, for example, social media comments. And finally, just a very practical procedural point, the Employment Appeal Tribunal was wanted to stress very as a final kind of point on procedure, the fact that with its decision, it felt that this could be a very streamlined process. It noted that the hearing in this case took 6 days to determine the preliminary issue of whether or not the belief qualified. It said that this should not ordinarily take more than a day, and indeed the very low threshold meant that if a belief wasn't akin to Nazism or totalitarianism, it should be quite clear that it falls within the purview of Section 10, and these things should be dealt with very quickly. So that at least is one bit of certainty that we've got from the decision. So with that, I hand back to Heather for the remainder of the topics. Thank you.
Thank you very much, Claire. That's very interesting. For those who joined late, by way of explanation or repetition of what I said at the beginning, Nick Toms, who was going to talk about the key disability discrimination cases, had at very short notice to depart for A&E with his son, who suffered an accident in a sports game. Not too serious, we hope, but serious enough for Nick to have to take him to A&E. So we don't have Nick, after all, talking about disability discrimination. Before I come on to the topics that I was going to cover, I will just highlight briefly the issues that Nick would have covered in more detail. However, because this has only arisen at short notice, I haven't had a chance to prepare it in any detail, so I hope you'll bear with me on that. So you can see on the slides, which Ray has kindly taken us to, the reference to the two cases that Nick was going to talk about, which between them span what are often or largely the two key causes of action under the Equality Act for disabled employees: the duty to make reasonable adjustments, which the Griffiths case was concerned with, and the Section 15 claim, which the NASA case was concerned with, both, as you will know, causes of action peculiar to cases involving the disability protected characteristic. Can we go to the next slide, please, Ray? And Nick has reminded you there in the second bullet point that a reasonable adjustment, as of course you know, requires the tribunal to identify the relevant provision, criterion or practice which caused the disabled claimant a substantial disadvantage compared to non-disabled employees. And if that is made out, was there any reasonable adjustment that might ameliorate the disadvantage? In Griffiths, the issue arose in a context of a subject matter that has come up in many disability cases, that's to say employers' sickness absence procedures. And the claimant in Griffiths was off work for 62 days as a result of a condition which amounted to a disability. And so when she was given a formal warning under the policy, she said, in effect, hang on a minute, I'm disabled. This policy puts me as a disabled person at a disadvantage along with other disabled people because we're more likely to need time off. And therefore, the duty to make reasonable adjustments arose. And she relied on two adjustments specifically. Firstly, that her disability-related absence should simply be discounted for the purposes of application of the policy and triggering warnings or other formal disciplinary action. And secondly, that she should be given extended targets under the policy in the future so that warnings were not triggered. She was unsuccessful before the Employment Tribunal and the Employment Appeal Tribunal. Apart from anything else, she also lost on other issues, as we will see, but as is apparent from Nick's bullet point at the bottom of that page, she lost because it was said that the PCP didn't cause a substantial disadvantage for disabled people because it was applied to everyone. Can you go to the next slide, please, Ray? Fortunately, the Court of Appeal put everyone straight on that. Well, I mean, one only has to think about the whole idea of the reasonable adjustment duty to appreciate that it is ridiculous, quite frankly, to suggest that simply because a policy is applied to everyone in the same way, that it does not trigger the reasonable adjustments duty, because the whole point about reasonable adjustments is that certain policies or practices or procedures will impact on the disabled in a more significant way. To use Lord Justice Elias's phrase from the Griffiths case, they will bite on the disabled. And in fact, the very same point had been established in the earlier case of O'Hanlon in 2007, referred to on the sheet, which in fact Nick and I appeared in. We ultimately didn't succeed in that case because the Court of Appeal held that reasonable adjustments didn't include bumping up someone's sick pay, because reasonable adjustments were about getting people back to work, not paying them all for being off work. But before the court even got to that stage, the court rejected the employer's arguments that there was no prima facie engagement of a duty to make reasonable adjustments, because said the employer, well, this is simply a policy, a sickness absence policy applied to everyone. So although the Court of Appeal said that in 2007, or I think probably 2006 was when the case was actually decided, here we were in 2015 with the Tribunal and the EAT making the same error of law. And I mean, I know anecdotally from experience that one used to face that argument time and again in cases. And I'm sure I wasn't alone. So one of the key things about Griffiths is it really put to bed that argument and emphasised it's never an answer to a reasonable adjustments claim to say, well, everyone has to face this policy or this procedure. The point is, does it bite hard or harder on the disabled or a particular section of those who are disabled? The second point, which again had cropped up in O'Hanlon, but which Lord Justice Elias made very clearly rejected in Griffiths, was the employer's argument that there was no duty to make reasonable adjustments, because if a non-disabled person who was unwell had been off for the same amount of time, then the same trigger points under the procedure would have applied. And as Lord Justice Elias explained, it's sort of allied to the previous point, but again, it's not in point. He used the analogy, as you see in the citation which Nick has set out there, of the blind man and the sighted man who both want to take a dog into a restaurant. The owner says no, and they're to both of them, and they're both subjected to the same disadvantage. They both can't take their dog into the restaurant. But for the disabled man, the blind man who relies on the dog heavily to assist him, then the impact is quite distinct. And therefore, it is simply not in point to say that the disabled and the non-disabled would be treated in the same way. Next slide, please, Ray. Nick concludes by making the point that, unfortunately for the claimant, Miss Griffiths, she in any event lost on the argument on the particular facts of that case, that the adjustment that she proposed was a reasonable one. But the case is significant, as I say, for laying down or confirming the principles that apply in relation to sickness absence policies, and indeed reasonable adjustments claims more broadly in terms of looking at what is a PCP and what is the appropriate comparator for these purposes. Could we go on to the next slide, please, Ray? The second case that Nick was going to talk about, I will talk about even more briefly. As you will know, Section 15 of the Equality Act, as Nick reminds us here, applies where a claimant has been subject to unfavourable treatment because of something arising in consequence of their disability. And if that stage is met, then which the respondent cannot show was a proportionate means of achieving a legitimate objective, i.e. the respondent can't justify it. And on the facts of this case, the claimant got a poor verbal reference, or alleged that his former employer had given a poor verbal reference because of his attendance record. And that led to the withdrawal of the offer of employment from a third party. And the claimant's argument was, well, you gave the poor reference because of my attendance record, and in turn my attendance was, quote, something arising in consequence of my disability, close quote, because it was because of my disability that I had to have time off work. And so the elements of the test that establish prima facie Section 15 discrimination are made out. If we can go to the next slide, please, Ray. And although the claimant had been unsuccessful below, the EAT basically accepted that also finding that the tribunal below had erred on their approach to the burden of proof, where they had basically, I'm summarising, but in effect required the claimant to prove the case in its entirety before finding that the burden of proof was satisfied, which, as Mrs. Justice Simler, the then president of the AT, pointed out, was not how the burden of proof provision was supposed to work. And she accepted that the claimant's argument was potentially a sound one. If my memory serves me correct, the case was then remitted for further findings to be made. I've only dealt with it briefly, but her judgment is contains a really helpful setting out of the elements of the Section 15 case and what needs to be shown. And effectively, once you have your unfavourable treatment, the two stages of causation, i.e. that the unfavourable treatment is because of something, which in turn has to arise in consequence of disability. And so it's those two stages of causation, those two links that need to be shown. Thank you, Ray. I think we've effectively covered the next slide as well. Oh yes, you stopped there. Just on the previous slide, the President also emphasised that motive was irrelevant to the Section 15 cause of action. Right, I'm going to stop impersonating Nick and go back to being me now. And as I mentioned in my introduction, I'm firstly going to talk about indirect discrimination. So if we just remind ourselves of the elements of the statutory test in Section 19 of the Act, it requires the application of a provision, criteria or practice, a PCP, to both, I emphasise both those who do and do not share the claimant's protected characteristic. The PCP puts or would put persons with whom the claimant shares the characteristic at a particular disadvantage compared to those who don't, and it puts the claimant at that disadvantage or would do so. And the respondent can't justify it, can't show it to be a proportionate means of achieving a legitimate aim. If we can go to the next slide, please. And the Supreme Court case that I wanted to talk about is Aesop. Well, it was two cases, Aesop and Naim, that were both before the Supreme Court because they raised similar issues. I wanted to talk about this case because it's one of my favourite cases under the Equality Act. Not that I have a hierarchy, a league table of favourite cases, but if I did, I think this would be pretty near the top. And the reason for that is because with characteristic lucidity, Baroness Hale, in giving the leading speech, just explodes completely in a few short, succinct paragraphs, all the fallacy in the thinking below in the Court of Appeal, and sets everyone right again as to what indirect discrimination is all about. Now, I'm actually going to come back to this slide because it summarised what's decided, because I think it's actually clearer to remind ourselves of the facts and issues first. So if we could go to the next slide, Ray. So in the first case, Aesop, just to remind you, Mr. Aesop was the lead claimant for a group of Home Office employees who alleged that an internal promotion test, the CSA, was indirectly discriminatory, both in terms of race and age. And the basis of the claim was that agreed statistics showed that proportionately BME and older candidates had a significantly lower pass rate for this test. But significantly, for the purposes of the argument in this case, neither party knew why or was able to suggest a reason why that was the case, that there was this lower pass rate for those two protected characteristic groups. The claimants had taken and failed the test. The Court of Appeal agreed with the Employment Tribunal, who on a preliminary hearing had held that that statistical disparity was not sufficient to show prima facie discrimination. It wasn't enough to say, look, mathematically, there's a disadvantage experienced by BME and older candidates. The court said the claimant has to show what that reason is, has to explain how it's linked to the protected characteristic, and has to show has to show that the claimants and others in the group are disadvantaged for the same reason. We then look at the issue in Naim, which is the next slide, please, Ray. This case really went one stage further, because there the reason for the treatment, which I will explain, was known, but the employer said, in effect, well, here we know what the reason for the disparate impact is, but we know it's a non-discriminatory reason. So come on, end of, can't be any indirect discrimination here. And the Court of Appeal accepted that argument. How did that arise? Well, the case was concerned with the prison services pay scheme, whereby employees progressed up the pay bands based on length of service and appraisals. Until 2002, there had been no Muslim chaplains employed by the prison service because there weren't very many Muslim prisoners. So they just have a chaplain come in on a sessional basis if one was needed, but there weren't any Muslim chaplains employed. So group disadvantage was made out in the statistical sense because Muslim chaplains had only been recruited post 2002, including the claimant who was recruited in 2004. And therefore, it was the longer serving Christian chaplains who were higher up the pay scales. And hence the disparate impact in terms of pay was made out. And as I say in the last paragraph there, the Court of Appeal not only agreed with the earlier Court of Appeal reasoning in Essop, but went further, holding it was fatal that the reason for the disparity was non-discriminatory and did not relate to a characteristic specific to Muslims, i.e. it was because simply because no Muslim chaplains were employed for a perfectly good reason prior to a certain date. So we then come back to what the Supreme Court decided. So could we go back 2 slides, please, Ray? Sorry to jump around. Perfect. So Baroness Hale wasn't having any of that. And in a leading judgment, which all the other members of the court agreed with, she said that the statutory definition does not require the reason for the group disadvantage to be identified. So it was enough for the statistical disparity that we saw in relation to those who did and didn't pass the CSA, the Internal Home Office test. It was enough for that to be shown to make out the group disparity element of the statutory definition. Similarly, the claimants did not have to positively show that they experienced the disadvantage for the same reason as others sharing their protected characteristic experienced the disadvantage. They didn't have to show they failed the test for the same reason. And then thirdly, in dealing with the Naim point that I've just summarised, the statutory definition did not require the reason for the disadvantage to be causally linked to the protected characteristic relied on. So translating it into Naim terms, it did not have to be shown that the disparity on the pay scales was somehow intrinsically linked to being a Muslim. If we could then go on, Ray, to, perfect, you're there ahead of me, onto Baroness Hale's reasoning. And this is just a brief summary. It's well worth reading her judgment. I mean, it is the leading case on indirect discrimination. It's the case you should always turn to first of all if you need to look at the elements of indirect discrimination. But in summary, these were some of her reasons for disagreeing with the Court of Appeal. That the wording of the statutory definition itself didn't expressly require it to be shown why, i.e. the reason why a PCP put one group at a disadvantage. Secondly, she contrasted the situation with direct discrimination, which obviously is founded on showing the reason for the less favourable treatment complained of. Whereas she said in relation to indirect discrimination, the causal link is between the PCP and the disadvantage suffered. You don't have to then look behind it to try and find the reason for it. And she emphasised that the reason for the disadvantage could be many and varied, including genetic factors. She gave examples, height criteria, you must be 6 foot tall to join the police force. societal expectations. So, for example, society's expectations that women will be the primary carer for family and home, or traditional employment practices, for example, in relation to pay scales. And she emphasised the reason need not be unlawful, nor under the control of the employer, nor in any way intrinsically linked to the protected characteristic. And then the next slide, we can see some of her other reasons. She emphasised as well, I mean, this ought to be obvious from the definition in section 19 itself, but I mean, again, I know anecdotally, I remember facing this argument time and again from respondents that there couldn't be indirect discrimination because not everyone in the claimant's protected characteristic group failed to meet the PCP or failed to be disadvantaged by the PCP. Well, that's not the test. What you're showing is that there's a disparity in impact, not that every single person who has that protected characteristic is disadvantaged by whatever the PCP is. You know, there may be a woman who is over 6 foot tall and can still join the police force. So she said that in the clearest possible terms, that it was irrelevant that some members of the disadvantaged group meet PCP. And she emphasised that, of course, it's still open to the respondent to justify the PCP. And then that last point is really one I've already covered. On a different note, but I mentioned for completeness, she also emphasised that in terms of deciding the size of the pool for the purposes of analysing whether there is a disparity, it should include all those affected by the PCP. Now, that's not new law. There's plenty of earlier cases that said that under the Equality Act and its forerunners. But again, it seems to be one of those old arguments that comes up again. And in one or other of these two cases, there had been an error made. I think it was in Naim in that regard, one of the stages below. And so, yet again, it was stressed that the pool should include all those affected by the PCP. Next slide, please, Ray. In terms of the outcomes in the particular case, because the ET had got the law wrong in ESSOP, the case was remitted to the ET. In Naim, in any event, the case had failed on justification, and the Supreme Court said, well, that was simply a conclusion of fact open to the tribunal. And so although there had been errors in the relation to the earlier parts of the statutory definition, and it was a case where there was prima facie religious discrimination, in fact, on the tribunal's findings, it was justified. And I think the most important point in terms of the overall sense that one derives from ESSOP is the point I've made in the last bullet point there, which is that Baroness Hale was at pains to emphasise that she had detected a reluctance in the courts below, particularly in the Court of Appeal, to treat the case as reaching the justification stage, that as if there was some sort of stigma on an employer who faced a court ruling that the first three elements of the statutory definition were satisfied and that therefore they had to justify the prima facie discrimination. Not so, said Baroness Hale, it's simply all part of the statutory definition and the employer may have a perfectly good reason. There's no shame in having to justify something that meets the first three criteria. And indeed, as the facts of Naim showed, and her very clear exposition of the way in which the three earlier parts of the statutory definition worked, I think have definitely made it easier post ESSOP for claimants to get through to the justification stage, and indeed respondents to make realistic concessions about those first three elements of the statutory definition, or some of them being satisfied, and tribunals and therefore appellate courts getting less tied up in knots in arguments about what's the size of the pool here and is there a PCP and so on. I mean, obviously those arguments still happen to an extent, but I think definitely less since this seminal case. And then, Ray, the last case I was going to talk about more briefly, included this one because we wanted to show an illustration of the limitations of the Act, as well as the good things. And as you will all know, the Act contains effectively a closed list of protected characteristics. So in this instance, race, which reminded you is defined in section 4 of the Act, it includes colour, nationality, ethnic or national origins. In two linked cases that were before the Supreme Court, the Onu case and the Taiwo case, the Supreme Court had to consider whether less favourable treatment because of a person's precarious immigration status could be equated to treatment because of nationality and therefore come within the direct discrimination provisions of the Act. In short, the Supreme Court said no, it couldn't. Although, if we go to the next slide, Ray, please. The court had a lot of sympathy with both claimants. Again, Baroness Howell gave the leading judgment, which the other members of the court agreed with. They were both migrant domestic workers from Nigeria who had been treated really, really badly and exploited by their employers whilst in London. And the court was entirely sympathetic to their plight. But affirmed that they did not have direct or indirect discrimination cases. There had been findings of fact made below, and obviously the position could be different if different findings of fact were made by the particular tribunal. But in each of these cases, the employment tribunal had found that the claimant was not treated badly because she was Nigerian or because she was black, for example, but rather because her migrant status made her vulnerable, given her dependency on her employer for continued employment and residence in the UK. In both instances, the claimants had visas to work for the particular employer in the UK. In both instances, the employer, in fact, had lied on the visa about how long the person had worked for them as well outside the UK and so on in order to get them into the UK. And they were wholly dependent on the employer for them being permitted to stay in this country. And so plainly they were in a very vulnerable position. If we go to the next slide, please. So the argument, which in fact in one of the cases succeeded at first instance, but then lost at each level above that, and in the other case lost at every level, was that immigration status and nationality are sufficiently interlinked that immigration status should be treated as equivalent to nationality, and thus within the Section 4 protected characteristic. Not so, said the Supreme Court, referring to various European Union cases, amongst others. In short, the only circumstances in which you can equate something which is not overtly a protected characteristic with a protected characteristic is if there is an exact correspondence between those who suffer the adverse treatment and those who would be of the same protected characteristic. An example which the court referred to from the domestic case law to make that clear is the Preddy and Bull case, the Christian owners of the B&B who said they would only let married couples stay in rooms with double beds. And that was a time before gay marriage was permitted. And therefore, whilst not every heterosexual couple would have been able to satisfy this requirement, every gay couple, for sure, 100% would not. And therefore, there was an exact correspondence between the requirement, which was not overtly in terms of sexual orientation, and the relevant protected characteristic there, sexual orientation. But in this case, as indeed had been said in earlier cases, it is only where there is that exact correspondence between people who suffer the adverse, the less favourable treatment and the protected characteristic in question, that the two can be equated with each other. Whereas, said the court, for example, in relation to immigration control, there are lots of non-British nationals living and working in the UK who didn't share the claimant's vulnerability and would not have been treated as they were. So although the courts were sympathetic to the claimant's situation, they are quite firm in holding there could be no direct discrimination claim under the Equality Act. And then if we could have the last slide, please, Ray. Baroness Hale said that didn't rule out a finding of indirect discrimination if, in an appropriate case, a relevant PCP that disadvantaged those of a particular nationality could be formulated. In that case, no one could think of a relevant PCP. And I must say I couldn't either, because the complaint essentially was about exploitation of a particular group of persons. It wasn't about a provision, criteria or practice that was applied to everyone, but impacted on particular groups disproportionately. But said Baroness Hale, never say never. And so that does remain a possible line of argument in the right sort of case. As I conclude by saying the decision emphasises that unlike under Article 14 of the European Convention on Human Rights, the Equality Act list of protected characteristics is not open-ended. And I think that is particularly a disadvantage in the employment sphere because the employment tribunals have no freestanding jurisdiction to hear claims under the Human Rights Act. In many other spheres, for those of us who also, for example, bring discrimination claims in the public law sphere or certain other spheres that lead to civil claims, one can claim in the alternative under the Equality Act and under the Human Rights Act, relying on Article 14, and then one has a much freer reign, as it were, in terms of the status that one can rely on in respect of discrimination. I mean, obviously there are downsides as well, because the discrimination can potentially be justified, unlike direct discrimination under the Act. But it is an interesting illustration of the fact that for employment tribunals, there is this, on the face of it, quite restricted list of circumstances in which a direct discrimination claim, or indeed any discrimination claim, can be made out, which is very different from the way that the law has developed in the civil courts as a result of the applicability of the Convention under the Human Rights Act. So I'm going to end it there, and thank you for bearing with us in this hot afternoon. I haven't had a chance to look while I've been speaking, but I'm going to look now, see if there's any questions in the chat, or if there aren't yet, if anyone would like to post a question in the chat in the next few minutes, we will be very happy to answer. I don't think there's any questions at the moment. What I could do, can I ask you a question, Claire, while also to give other people a chance to think if they've got any questions?
Of course. Which
is following on from the points you were raising in relation to forced data. As you say, the bar is set really low on the face of it in terms of beliefs that are so offensive that they would not attract the protection of the Equality Act. And you highlighted racist views in light of recent events. I mean, do you think, is there a scenario that's sort of something less extreme than Nazism that would fall outside the protection of the religion and belief provisions, or does something even kind of pretty overt racism, will that be protected? With the caveat, of course, that the person then has to go on to make out their cause of action, but will they get that prima facie protection under the Act?
I think it's hard to quibble with the quite clear statements of principle from the tribunal in that case. I mean, you know, Nazism is quite an unhelpful example in some respects, because it seems such a clear-cut example of a belief that obviously would fail the test. It would almost be more helpful to have examples that fall a little bit closer to the mark. But you know, the case law in Article 10 has always been very clear that, you know, it doesn't just apply to views and opinions that are positive. The same protection applies to views and opinions that offend, that shock, and that disturb. And so it's difficult to see really any or think of any concrete examples where we do get over into what the court was really focused on, which was the kind of the destruction of the rights of others. I mean, one example that I did note from the forced data decision, an example that the tribunal did give, the appeal tribunal did give, was where somebody expresses the view that immigrants to the UK ought to be forcibly and immediately deported for the good of the country. And the tribunal expressed the view there that that was the kind of thing that could perhaps incite violence or destroy the rights of immigrants. But it was quite notable that the tribunal framed it in that way. It went beyond mere expression of racist views, for example, and went further into the sort of belief that they ought to be immediately deported. So it seems to me the tribunal is setting quite a clear statement of principle that they've really got to be, akin to Nazism, or really at that Article 17 threshold of inciting violence towards others, or aiming at the destruction of rights of others. So it does seem a very high threshold indeed.
Do you know if there's any appeal by the respondent in that case?
I don't know, actually. I'd be interested to know if anyone has any intel on what's happening with it, because I expect it's a lot of people will follow very closely.
We don't seem to have had any questions yet. So unless you want to ask me a question, I'm not inviting it, merely giving you the opportunity. But unless you do, then I think we may be off the hook. Right. Well, I think we'll draw things to a close then if there are any questions. Thank you all very much for attending this afternoon. I hope if you haven't already received copies of the packs with the slides, then you will do so. And
Thank you.
Yeah, that just leaves me to say goodbye then.
Thanks, everyone.
All right. Bye-bye.